Hello, everyone. Welcome. Please bear with us a few more moments. We're trying to figure out. There's one panelist who's having, of course, even if there are many years of Zoom, the Zoom is in our lives. We always have glitches. So just a second to see if we can find one of our presenters who was unable to log in to our webinar, and we'll just wait one more minute. And if not, we will start our program and hopefully have him join us as soon as possible. Okay, let me start, and hopefully Professor Zering will join us in a second. So let me just share my screen. I'm very much a slides person, so I need my slides. So uh, can you see my slides and hear me okay? Perfect. Okay, so welcome everyone to our webinar on central bank independence and global perspective. What's so special about central banks? I thought I'd say something about why we're doing this webinar in general, and especially now. And I guess the way to think about it or start thinking about it is that central banks and banking law more generally is now an established field of law, even though it's probably viewed by many as kind of specialized, niche, technical, but still justifiably a prestigious field of study. But recent events sort of pushed, as happens sometimes with areas that seem kind of very technical and specialized. Recent events sort of pushed that field of banking law and central banking law to the spotlight, certainly in the United States, and certain events that are related to the second Trump administration. So, one of the distinctive features of the second Trump administration is our extremely bold assertions of presidential control over the state apparatus, and especially, and this is kind of the familiar picture from Trump that we should have probably anticipated. President Trump's sort of fascination and interest in removing people, officers in key agencies throughout the American, what we call sometimes American administrative state. So it's really everywhere. President Trump really removed at will senior agency officials in really key agencies like the FTC, the Federal Trade Commission, the NLRB, the National Labor Relations Board, or the MSPB, the Merit Systems Protection Board. But most recently, or kind of in the spate of removals, of course, he also tried to remove governor of the Federal Reserve Board, Governor Lisa Cook. We will hear more, hopefully, soon about what are the circumstances or the claims that were presented against Governor Cook. But I just want to highlight before we kind of dive into this that the Supreme Court, the United States Supreme Court, sent important signals about how it kind of views those bold assertions of powers to remove senior agency officials in what is called the shadow docket. This is not the docket where the court really hears fully briefed merits cases. But when the court intervenes on basically temporary remedies that are given by lower courts in this shadow docket, so the Supreme Court essentially gave us a signal that most agencies, Trump's attempts to remove senior officials, like in the FTC, NLRB, and MSPB, are going to be potentially okay. There's a good claim by the president that it's okay to remove those senior officials from those agencies at will. But the Fed, so the court said in this shadow docket, may be different. And specifically, this is kind of what the court said in the decision where it made that signal. The court said it sees the Federal Reserve as something different from these other agencies. The Federal Reserve is a uniquely structured quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States. So we thought that given what is going on, it's really a good time to ask sort of two key questions. One is, how do other countries think about the subject of independence of central banks? And the second is, are central banks truly special relative to other agencies, as the Supreme Court indicates? And to the extent that it's that is really the case, does it really affect the question of removal of senior officials in central banks? So I just want to say just briefly that about to say who are the sponsors of this event. The event was sponsored by three sort of institutions. The first, the Comparative Administrative Law Listserv, which is again a terrific resource that I encourage anyone who's interested in administrative law across the world to consider joining. It's sponsored by the University of Arizona College of Law, where I specifically teach, and finally by the Review of European Administrative Law, Real Law Blog, also a terrific resource attached to a terrific journal in the field talking about important issues of administrative law across Europe. The structure of the webinar, we're going to try and do it in two parts for 2 hours. The part one will feature, in addition to me as a kind of moderator, also three distinguished speakers, Professor David Zering from Wharton, Mr. Michael Salib from the Bank of England, and Mr. Michael Ioannidis from the European Central Bank and Max Planck. We will try and break for a few minutes just so that everyone can have their water and run to the bathroom to the extent that they're interested in kind of sitting through the entire webinar, and then immediately move to the second part, which will be moderated by my colleague, Professor Izoult Marik from Essex and Louvain, Professor Eugenio Garcia Udibro from Yale and Catholic University in Chile, Professor Shireen Morris from Macquarie, and Professor Frédéric Allemande from Luxembourg. So just one thing to know before we give you some more details about our speakers. Just know the Q&A function is enabled, so please feel free to kind of put in your questions, and I will look at them throughout and call on them. And sometimes I can also invite the attendees to actually introduce those questions themselves. Okay, we're going to start with the first panel. Just a bit more about our presenter. I don't know, is Professor Zering around? So Professor Zering, he was our missing panelist who will hopefully join us as we start this, but I will introduce him formally because I know we will try and find him eventually. So Professor Zering, he's the Elizabeth Purcell Professor in Legal Studies and Business Ethics Department at the Wharton School of the University of Pennsylvania. He writes at the intersection of financial regulation, international law, and administrative law. He has written over 50 articles on those subjects, along with a monograph on the globalized governance, finance, and taught in distinguished institutions, in addition, of course, to Wharton, at Bucerius, Cambridge, Penn, Vanderbilt, and Washington and Lee Law Schools. Then, actually, Mr. Salib is going to be our first speaker. Mr. Salib is the Deputy Secretary at the Bank of England with responsibility for a range of governance and ethics issues. Prior to his role as Deputy Secretary, Mr. Salib served as a Deputy Head of Legal and Private Secretary to the bank's General Counsel. Mr. Salib, also joined the bank from the law firm Freshfields in 2013 and holds a law degree from the University of Oxford and a master's in banking and financial regulation from the London School of Economics. He has published a number of really interesting articles to legal and relating to legal and governance issues relating to the Bank of England and central banking. And finally, Mr. Michael Ioannidis. Sorry, Michael, I see that I myself has misspelled your name, Ioannidis. Sorry, it is fine. It's just I'm reading too quickly. So Mr. Ioannidis wears two hats, one institutional and one academic. He works as an advisor at the European Central Bank and as a senior research fellow at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg. His work primarily focuses on constitutional issues related to the economic and monetary union and related questions in public international law. So, okay, all these niceties are done, and we can start getting down to business. So I think because we don't have Professor Zering with us, Michael Salib, can I ask you to start us off with your presentation?
Absolutely. Can you hear me okay?
Yes, we can hear you okay, and we can see your slides, and I will be keeping on the time.
Excellent. Thank you, Oren. And can I just say thanks so much for organizing this really excellent event. I'm really looking forward to the discussion. So, as you said, I'm going to talk about this issue from the perspective of the Bank of England, specifically focusing on the protections that we have in place in the UK around the personal independence of the governors of the Bank of England. Obviously, we're following the litigation in the US extremely closely. And only today, the governor of the Bank of England was before Parliament. He was asked about the case and the implications of it. It's obviously attracted a lot of attention over here in the UK. I just thought we'd start with some framing in terms of how we can think about a legal articulation of central bank independence. I appreciate a lot of experts in the room who will be very familiar with this kind of framing, but for those who are less familiar with how we think about central bank independence in a legal context, this is instructive, I think, to think about it in 4 pillars. So you can have this concept of constitutional independence. This is an entrenched provision in a constitution that guarantees central bank independence. I think the ECB, and Michael will talk later to this, is perhaps a high watermark of this. It's entrenched in the Maastricht Treaty. No one country, Germany or France, can change the independence of the ECB. The Bank of England does not have that. A government with a simple majority could revoke central bank independence in the UK, but clearly the market reaction there would be a binding constraint. And the second pillar is around institutional independence. So is there a power of direction of the executive over the central bank? So there's an interesting point here with the Fed does not have formal legal powers of direction of override that the president has, whereas in the UK, the Treasury does have formal, on the statute book, legal powers of direction in extraordinary circumstances over the Bank of England, including on monetary policy and extreme economic circumstances. Never used, but those nuclear powers are there on the statute book. The third pillar is around financial independence, so budgetary independence. You control your own budget, and economic independence around monetary financing and financing government deficits. And the final pillar, which is what I'm going to focus on this afternoon, is around personal independence. And you can think about this in a number of ways, and I've structured it here as how we're going to approach it. So around appointments, terms, removal, parliamentary oversight, and just some reflections I'm going to offer at the end around comparisons with the UK and the US framework on this topic. So appointment I'll deal with relatively briefly because I think we all want to get to the topic of removals, but appointment's important. And in the UK, the appointment of governors of the Bank of England is a matter for the Crown, as you would expect, very old-fashioned. But in reality, it is the Prime Minister and the Chancellor who make that appointment, but formally it is the Crown that makes it. And there is a disqualification provision if you are serving as a minister or employed in a government department that would disqualify you from being governor of the Bank of England. But former ministers and former government officials clearly are appointable. Once appointed, they must work exclusively for the bank, according to the statute, which is great for clearing of conflicts of interests that people may hold before they join. And the appointment process itself is absolutely run by the Treasury, as you'd expect, given they are the ones who are responsible for making the recommendations on the appointment. But the bank is involved. So we do the conflicts of interest assessments that we provide to the recruitment panels when they consider members. And we also often tend to have a senior member of the bank, often of our board, involved in the recruitment panel itself. Remuneration is set by Remuneration Committee, and we also has policies on managing conflicts of interest, as you'd expect. But I won't say anything more on that this afternoon. Term. So this is an interesting little factoid for you. The record term for a Bank of England governor was 24 years, which is Governor Montague Norman, who was in post from 1920 to 1944. And I think in that time frame, he saw off 11 chancellors of the Exchequer. So a very long term, too long, frankly. And certainly informed by that experience, immediately after World War II, when the bank was taken into public ownership, they introduced term limits for governors. And originally, that was for 5 years. So it was renewable after 5 years. But there was some controversy in 2008 about whether Mervyn King's appointment would be renewed by Gordon Brown and Alistair Darling. And there's a nice quote here from David Cameron, who was the leader of the opposition at the time. The problem is that people think that now the Bank of England is independent, the argument's done and dusted. It isn't. The Chancellor has the right to reappoint the governor of the bank. And as we've seen over recent weeks and months, that creates instability. I believe it's time to have a single non-renewable term for the governor to insulate him or her from political pressure. And when the Conservatives entered the coalition government in 2010, they brought about that change. So in 2012, the law was changed in the UK. So now the governor serves a single non-renewable 8-year term. And now the topic of removal, which I think will be of most interest to people. So in the UK, there are 3 statutory grounds for removal in the Bank of England Act 1998. And these apply for all court members, including the governor. And by court, by the way, the bank has this old-fashioned phrase called the Court of Directors, which is essentially its board, its governing board. And those grounds are absence from court meetings for over 3 months, bankruptcy, which you might think is, does that happen? Yes, it has happened multiple times. In the 18th century, we lost courts of directors to bankruptcy, and they had to stand down when the bank was operating as a private bank. But the third, and certainly of most interest, I think, to this audience, is this phrase, unable or unfit to discharge their duties as a member. That's all it says on the statute, unable or unfit. It's quite a common phrase in independent agencies in the UK as a ground for removal. There's surprisingly little case law on it, which might suggest the sometimes benign nature of British policy that people just resign out of embarrassment rather than force a removal. But I think unable clearly indicates an incapacitation by physical or mental illness. The act before it referred to unable or unfit referred to lunacy, and if the governor becomes a lunatic, they modernized that in 1998 to refer to unable or unfit. Unfit, I think, denotes something around conduct or character. So a situation about serious misconduct, criminal convictions involving dishonesty, or a serious conflict of interest issue. But these provisions haven't been tested before courts of law, and there's been surprisingly little even parliamentary debate when the provisions were introduced. But I think a key point to bring out on the topic on removal is that in the UK framework, the instigation of the process for removal lies with the bank's board, the bank's court of directors, and not the Treasury. So Treasury makes the appointment, as I say, but the removal process is instigated by the bank's board itself, although the Chancellor must approve a decision to remove a governor. Moving on to parliamentary oversight, just big picture in the UK, parliamentary oversight is often undertaken by these groups called select committees. And the Bank of England's context, it is the Treasury Committee that's responsible for overseeing the bank and the Treasury. And they're increasingly muscular in recent years, including on the issue of appointments and removals, when there have been removals of other agencies. And one of the key focuses they do when they look at appointments is to assess the independence from government of candidates. That's one of the things they expressly look at. And as I say, they've become more muscular over time. And the first pre-appointment hearing with a governor, so they've been doing it for some of the Monetary Policy Committee members since 1998, but the first formal pre-appointment hearing they had with the governor was in 2013 with Governor Carney. And that was with the expressly stated aim of providing the new governor with greater authority and independence from the day-to-day pressures of politics and politicians. Now, it is important to emphasize this is not a US-style confirmatory hearing. It has no legal basis. There is no formal veto power of appointments or removals. But that's not to say that there haven't been attempts to do that. So multiple times when I was researching for this talk, I was surprised how many times it's come up that they did try and secure a parliamentary veto over governor appointments and removals. And I found this nice quote from the debates in 1998 where they said, "We have to ask ourselves whether in practice confirmatory hearings improve matters. Our main experience of confirmatory hearings in the United States of America, and anybody who has seen those would walk a million miles before introducing anything like that into the British Constitution. I certainly would." But things have moved on since then. The Treasury Committee has actually managed to secure a veto power for appointment and removal in the case of the chair of the Office for Budget Responsibility. So for those not familiar with that, the OBR is the UK's independent economic and fiscal watchdog. So they do have that power now, which was a watershed moment. And the question came up, well, shouldn't this also apply to the Bank of England? And the rationale for the distinction that the government drew was the OBR was intended to assist Parliament in holding the executive accountable, whereas the governor carries out executive functions on behalf of the state. So there is a kind of separation of powers or constitutional structure point there to explain the distinction. I won't be surprised if this point, though, comes up again in the future. And then just to round up some final reflections on the UK and the US framework, I think, having looked at the US framework quite a bit from previous work, I mean, I think it's absolutely fair to say that in general, the Fed is more legally independent than the Bank of England. I would actually say significantly more in terms of the legal framework. The Bank of England is a subsidiary of our Treasury. It's a wholly owned subsidiary. They're our shareholder, whereas the Fed is an independent agency created by Congress. The Bank of England is subject to powers of direction from the Treasury. As I say, they've never been used, but they're there on the statute book. Whereas I don't think the Fed is subject to any equivalent formal legal powers of direction. We can talk about extra legal separately, maybe in the discussion. And the Bank of England has its inflation target and remit set by the Treasury. So our 2% target on inflation is set by the Treasury, not by the bank itself, whereas the Fed itself determines its goal for price stability. But in the specific field of personal independence, I think the bank arguably has greater legal protection because, as I said, we've got this 8-year non-renewable term. It's precisely to avoid speculation around renewals as opposed to the 4-year term of a Fed chair. There is a little more detail on the statutory grounds for removal. As I said, there's 3 grounds there, as opposed to the more open-ended for cause ground in the case of the Fed. But what I'll just say as a postscript to that, I think people in the UK will be following very closely what the Supreme Court says about for cause in the US, because I think people think there could be read across into what unable or unfit means in the UK. And then finally, the instigation of removal lies with the bank's court, as opposed in the hands of the executive, the president in the US case. And I think those differences there reflect the broader constitutional and political traditions between the US and the UK. We're a parliamentary democracy. We don't have separation powers in quite the clear-cut way that the US does in its framework. But notwithstanding that, there's absolutely scope for cross-pollination of ideas. And so 100%, the greater oversight by the legislature of appointments is absolutely being inspired by the US experience, even if we've not gone the full way. So I'm going to stop there, Oren. I hope that was useful, and I hope the UK perspective offers something to the debate.
Terrific, Michael. Thank you so much. Hi, Professor Zering. Hi, David. Welcome. I'm sorry about the glitch. This is like life post. It doesn't matter how many years we are sort of accustomed to Zoom. It's bound to happen, and you were the victim this time. But listen,
Well,
if we need to, sorry.
I'm sure it's entirely my fault, and I apologize to everyone. Thanks for being. It's a pleasure to be here. But anyway, I'm
No,
here
but
now. Thank
yeah,
goodness.
the question is, are you feeling ready to give your pitch? Because we were hoping that you kind of can help us contextualize what's going on in the U.S. But it's also okay if you need a bit of a breather before, and we can start with Michael Ioannidis.
I am happy to go.
Okay,
Let me
perfect.
see if I can find the very small number of slides that I have. I think it's just 3. And if I don't, I'll
First
just
off,
like
that the
start.
share function is not gonna, mess up with us.
Yeah, I know. I'm just looking, and where is it? Um, this may not be fated to be. Okay. Maybe we will not do that. What happens if I close this? Okay. Is it okay if I just talk instead of share slides?
Totally.
Okay. So
We're
I
keeping time,
understand that
so
you want. I'll try to talk for like 7 minutes. Does that sound about right? Okay.
sounds great.
And what I was going to do when I talked to you about the Lisa Cook litigation that is, threatening the independence of the central bank, we can also talk about the Jerome Powell um, investigation, if you like. But I caught the tail end of Michael Salib's talk, where he noted that that the Bank of England is in many ways less independent than the Federal Reserve. And all of those points are well taken. But I think it's worth establishing that, at least as far as appointments go, and he was talking about that, the Fed's independence rests on some pretty narrow grounds. So one thing that has guaranteed the Fed's independence is the so-called Treasury-Fed Accord of 1951, where Treasury decided to let the Fed set interest rates independent of the sort of fiscal interests of the rest of the government in borrowing money cheaply. But all the Treasury Fed Accord says publicly is that the Treasury and the Federal Reserve System have now reached full accord with respect to debt management and monetary policies to be pursued and for furthering their common purpose to assure that the successful financing of the government's requirements and, at the same time, to minimize monetization of the public debt. So that's one of the key documents of Federal Reserve independence. And note that it could not be a less formal document as a matter of administrative law. It's a memo recounting an agreement between two different parts of the government. Those kinds of things under ordinary administrative law principles could be revoked at any time for any reason. It's not like the Treasury Fed Accord went through notice and comment. It's not even clear what we can observe from that accord or what exactly it covers. That's it, a public announcement in 1951. Okay, so that substantive independence is shared by some removal protections for Fed officials. Those are contained in 12 USC 252, which provides for 14-year terms for the member of the board, unless sooner removed for cause by the president. And then 252 goes on to say, of the persons thus appointed, one shall be designated by the president, by and with the advice and consent of the Senate, to serve as chairman of the board for a term of 4 years. Okay, so what kind of protections from removal follow from this statutory protection of the Federal Reserve Act? Well, I think members of the Board of Governors can only be removed for cause. That's not the case for the chair of the Federal Reserve, who does not enjoy for-cause protections, though he would then go back to being a member of the Board of Governors, and he would enjoy for-cause protections there. Many American statutes with for-cause protections identify sort of what the causes might be, malfeasance of duty in office, that kind of thing. The Fed statute does not say what cause requires. That brings us to the Lisa Cook litigation. So she was a member of the Board of Federal Governors, and the president purported to fire her for lying about whether a second home on a mortgage application was in fact a primary residence. It's not clear how strong this claim is or anything like that, but that's the claim. And she has contested her removal, sued over the purported removal, and so far succeeded in that suit. And that's one of the I'll try not to go too long here, but that's one of the things I'd like to take away in a realpolitik kind of way. For-cause removal protections were enjoyed by a variety of federal agency heads in the past. And I think it's pretty clear to Supreme Court observers that those protections are about to go away because of a case called Slaughter versus Trump, where Trump removed a commissioner on the Federal Trade Commission who had for-cause removal protection, and he did not remove her for cause. And she's about to lose that case. However, the Supreme Court has also made it clear that it views the Fed as different from other agencies with for-cause removal protections. And it sort of backed up that distinction by, even though the facts are different, separating Lisa Cook's case from the Slaughter case, which could have been combined with the cases of other removals of federal officials and has been combined with the removal of the chair of the National Labor Relations Board, for what it's worth, and hearing it on a different date, and allowing her to continue in her job until the Supreme Court had a chance to review her case. That is not something that the Supreme Court has afforded other removed agency officials with for-cause protection. So my first takeaway on this case, in a realpolitik kind of way, is I think Lisa Cook's going to win her case. I don't think the Supreme Court would have separated the cases from Slaughter and Wilcox if they weren't going to retain her. I don't think they would have let her stay in her job. And I don't think they would have said, as they have done in certain orders on sort of separation of powers in American jurisprudence, that that she could stay in her job, as they have not let anyone else with for-cause protections do until they get a chance to finally resolve the case. Okay, second, one interesting question in American administrative law is what process is required for for-cause removal? Did the president give Cook the process by thinking in his head, why am I removing her? Oh, I've got a reason. I don't have to tell you what it is. Does she deserve some kind of hearing, which you sometimes hear about in American administrative law? Does she have a property right in her position as a member of the Board of Governors of the Federal Reserve? And if so, what process is required for the deprivation of that sort of property? That's just an interesting question in American administrative law, which we have no knowledge about because oddly enough, Lisa Cook is, and the Trump administration people are basically the first for-cause protected officers to be removed from office since the passage of the Administrative Procedure Act. There was a couple of removals for cause in like 1906, and so we could look to those cases to see what for cause removal process requires, but we just don't know. And one interesting question about this case is, will we find out more about that? I think I've gone for 7 minutes, so I don't want to go too long. I know there's lots of people who have things to say, but so just to review, there's tons of other interesting questions about this case, interesting questions about presidential control over monetary policy. But I think it's fair to say that central bank independence is cultural as well as statutory, and the statutory protections are uneven. Second, some of those statutory protections include for-cause removal protections, but the for-cause removal has not been defined and is somewhat differently defined when it comes to the Fed than when it comes to other agencies. And finally, we just don't know what kind of process is required for for-cause removal. And so even though I suspect that Lisa Cook will win our case, it'll be interesting to see if there's information or evidence that we derive from a result of this litigation or the Supreme Court's opinion that tells us a little something about that particular issue in administrative law. Let me leave it there and turn it back over to Oren.
Okay, terrific. So I think we're going to drill you down on some of the other aspects of that when we get to the Q&A.
Great.
But with that, let's move to Michael Ioannidis to give us the European Central Bank perspective. And Michael, you have 12 minutes, so don't rush. Take your time.
Thank you. I think it will be enough. I mean, I have in mind to actually say first a few points about the general constitutional framework in which European central banking is embedded, and then move on to say something more specifically on central bank independence. And the reason for that is that as everything in the European Union, things are complicated. I mean, the obvious thing is that here we're having a central bank without a traditional state, right? So we have a public entity that is not a state in the sense of the United Kingdom of the United States. So, and yet European central banking represents the most advanced aspects of European federalism. So in this multifaceted process of developing the European project, central banking is the most advanced. The two elements of how that works is, first of all, that when we think of European central banking, our minds goes directly to the ECB, to the European Central Bank, the institution with its seat in Frankfurt. Monetary policy, however, is assigned by European Union law to the Eurosystem, to a federal structure that comprises of the European Central Bank, so the institution seated in Frankfurt, plus the 21 national central banks of the countries that have adopted the euro. So it is this Eurosystem, a federal structure on top of which sits the ECB, that is responsible for monetary policy in Europe. The second important federal element of the system is that the central organ of the ECB, now this institution sitting in Frankfurt, it is itself comprised by two types of officials. 6 of them are appointed by the European Union itself, so they are union officials, like President Lagarde, and the rest of them are the governors of the 21 national central banks that have adopted the euro. So also the central decision-making body of the ECB represents this federal multi-level function. So this is the first element I wanted to raise. So European central banking, a federalized area of European policy making. The second point related to that is that in the European Union, we don't have a unitary executive in the sense of the US or the UK. At least we have institutions vested with executive powers, like the European Commission, but macroeconomic decision-making is basically decentralized. It is with a nation, with the member states, so with the national governments. and also the possibilities of engaging with the central bank, that means it's decentralized. It means that we usually use the concept of asymmetry in European Union law and policy to describe the fact that we have a federalized monetary policy, but a decentralized macroeconomic policy and other areas of executive. So this is the second element that I think is critical and I wanted to raise. The third is that in our case, European central banking, including the rules of independence, are of constitutional nature. So they are not statutory, they are not administrative law, they are constitutional law. Practically, that means that they are contained in the treaties, which for us has maybe not the name constitution, but for all its functions, all its legal value, and all its, actually very importantly, vocabulary, it says legal vocabulary, is of constitutional nature. There is where you find the basic rules of central banking, including those of independence. So it means that it cannot be changed by the parliament. And it also means that theories like the theory of delegation do not apply to us. No parliament has delegated power to the central bank. The central bank is born in the constitution itself. So in a way, it stands next to our other constitutional organs, the parliament, the commission, the Court of Justice. So we have a kind of status that is next to this. And of course, it's not a subsidiary of the Treasury, which we don't have a point that relates to what Michael said before. So bringing all these three elements together means that there is neither constitutional room in Europe nor political room for something like a unitary executive theory. So we have a constitutional setting that has constitutional and inside checks and balances, and the central bank belongs there. And we have a decentralized, if you want, you can also see it as a weaker federal executive than the one there is in the United States. So the central bank is called to operate within this constitutional environment that is very special, and I would say creates the preconditions for high protection of its independence. That is entrenched by the principle of independence being a constitutional principle. What do I mean by the word principle? I mean, some of you constitutional lawyers amongst us may be familiar with the distinction between rule and principle. Principle in European constitutional law means that there is a norm that is reflected in various provisions of the Constitution and guides their interpretation. So independence is set out in different aspects, in different parts of the Constitution, depending on its function. So we traditionally, and for methodological reasons, split independence in Europe in 4 categories. We speak of institutional independence, functional independence, personal independence, and financial independence. I will say a few more things about the 2 last categories because I think they are more relevant for the comparative exercise we're engaged in. Personal and financial independence. Personal independence is again part of our Constitution. So not in a statute, not in a special central bank act. It is in the statute of the ECB, which is part of the treaties, our Constitution, in 2 provisions, Article 11, paragraph 4 and 14.2 of the statute, depending on who it protects. If it protects the union officials, as I said before, or those national governors that sit in the union body. I won't go into details. We can discuss that later in the discussion, but I want to highlight 2 aspects. The first is the equivalent of for cause. What are the reasons for dismissal? We also have a specified reasons for dismissal, and there are 2. If the member of the governing council no longer fulfills the conditions required for the performance of their duties, so no fulfillment of conditions, And the second possibility of dismissal, it's that that person is guilty of serious misconduct. So this is the second heading that allows dismissal. So first element is that we have a limited, as I think it also is the case in the US and the UK, limited number of possibilities for dismissing a member of the governing council. The second, and I think equally important, or even more important, is the who dismisses and what judicial remedies are available for dismissals. Union officials that participate in the governing council, so these 6 members, can only be dismissed by the Court of Justice. So our Supreme Court, not by an executive organ. And that's a very high level of protection. Things are different for this second and more numerous category of members of the governing council that are the national governors who participate ex officio to the governing council. They're national officials, so they are appointed by the government of France, Latvia, Italy. However, and accordingly, their reasons for their process of dismissal is regulated by national law. Our constitution awards them, however, an extraordinary judicial remedy. They can go to the Court of Justice and they can ask for an annulment of any act that violates the term of office. And for us, this is extraordinary because the European Court of Justice in general has no power to annul national actions. Okay, so only national courts can annul national actions. It is the single only case where the Court of Justice, the European Court, our Supreme Court of the Union, has decided that it has the extraordinary power to go into the national legal order, penetrate, and annul, remove the action that violates independence. It's unprecedented, and this is something that was set in the case that, the most important case that we had on dismissal of a governor in 2019. So a precedent that, in a way, could be also relevant for our comparative discussion there. The case, many of you know it very well, is the case of Rimšević versus Latvia. Again, we can discuss details in the discussion. I will simply mention here that this case involved the suspension of the Latvian governor and member of the governing council by the executive, by the criminal system, judicial system of Latvia, on the grounds of suspicions of bribery. Mr. Rimšević, the governor, and the ECB disagreed with that, and they brought the case before the Court of Justice. The Court of Justice, in a fundamental judgment decided in 2019, decided that the conditions were not fulfilled, so that the governance of Latvia did not present sufficient evidence that would guarantee, that would show that Mr. Rimšević was guilty of serious misconduct, the for-cause equivalent that you have. And for that reason, annulled the measures, the suspension measures for Mr. Rimšević, and allowed him to return to office.
Michael, you're just almost at time, just so you know.
Yes, I'm putting a full stop on that. Just a final word on financial independence, because that relates to building central banks. And I understand that this is also an issue now in the United States. And we had issues with going beyond budget when we built our main building in 2014-15. That fell squarely within the financial independence of the central bank. So it's something that we did with our own funds, and the control of how the money was spent was covered by this concept. Again, something that we might want to discuss later in the discussion.
Okay, terrific. Thank you. Can I ask you, Michael Salib, can you turn on your camera? Oh, yes, you're here. Okay, so hi, thank you again for the rich details and presentations. Here's one thing just to ask, given what's going on in the Cook case, and to kind of kick us off maybe kind of in more details into what's going on. So as David said, one claim that is pretty important for the context of the case is that there's something special about central banks. I mean, in the US, the kind of context is that it's really hard if you just look at the Fed as a kind of exercising, just doing what other agencies are doing, or exercising what can be labeled as executive power. It gives a lot of credibility in the US to now the claim that the president is, because it is vested with the power, with the executive power under the Constitution, to remove at will the heads of those agencies. But the Fed and Cook, the argument for Cook is trying to develop this argument that there's something special about the Fed. The Fed is not just executive power. And of course, David, you will have more details to give us on this. It's just executive power. There's something unique about the Fed. It's system stabilizing, or it's quasi-private. We need not think about it as executive power. So I want to understand, so from what Michael Ioannidis said, it sounds like that kind of argument has some credibility, at least in the European context, given at least the formal constitutional standing of the European Central Bank. So I wonder if that's correct, if that kind of story about the uniqueness of central banks is something credible for the European context. And how does that argument play into kind of the UK context? Because is it really something that would kind of have any credibility in a system like the UK? And I just want to, one thing that I want to flag, some people in the United States in this discussion about whether the Fed is special, it's not really special, or it seems very executive. And this is something that maybe a hobby horse of mine, given that one of the things that I'm interested in is comparative public law and comparative constitutional law. Some constitutional scholars of comparative constitutional law are making an argument that now we need to move beyond separation of powers. There are actually institutions that are doing something else that is not executive, not legislative, not judicial, but they're called sometimes integrity branch or fourth branch institutions. So one thing that I wanted to ask you is that argument that doesn't have place still in the United States, in part because, comparative constitutional law is not something that the US Supreme Court is really interested in, or maybe administrative law scholars in the United States are interested in. Can we think about the central banks as a kind of a unique branch of government, integrity, system stabilizing? How would these arguments play in other countries, especially in Europe and in the UK? And how much is it important, David, for the US? Whoever wants to take this.
All right, I'm happy to have a go from the UK perspective first. So, yeah, I mean, I think we should distinguish, is it unique in law and is it unique in practice? There is some overlap, but in some senses, like in law, the central bank isn't that unique. I mean, the bank thing is very old. It's been around for 330 years. It has a unique kind of constitution that was created, but in terms of its modern architecture, it's increasingly governed by statute, much like the other key regulator in the UK, which is the Financial Conduct Authority. There's a lot of similarities in how it's drafted, and how it's subject to judicial review and tribunals and so on and so forth. But the uniqueness, I'd say, not necessarily comes from the legal context, but more the fact that, it is very old, a very long history. It's a lot harder to abolish a central bank, although the US has done it several times, than it is to abolish, say, a conduct regulator, which the UK has done post-crisis. There's a sense that the Bank of England will always be around, given that historical context. The second is the market reaction. So that really is a conditioning factor in terms of how people approach the central bank. And there's an amazing memo that Nigel Lawson, who was Chancellor in the 80s, wrote to Margaret Thatcher when he first proposed they make the Bank of England independent. And he acknowledged, like, some Labour government could come in the year after we pass this and repeal it, but they won't, because the market reaction will be so strong. So once we do this, it'll be embedded in the constitution. But Margaret Thatcher rejected Nigel Lawson's attempts to make the Bank of England independent because she wanted to ensure there was democratic control. And the third element is, perhaps given that because of that age and given the market reaction, is there is a degree of deference, I think. So there haven't been that many cases involving the Bank of England that have gone before the law courts in recent years, but there was a couple during the 07-08 crisis, and you could see judges showing a great degree of deference to the central bank in terms of its economic expertise and a real reluctance to tread into that space. You'll see that in the European litigation, which I'm sure Michael can speak to. So that is on the uniqueness. On the fourth branch discussion, I think that's quite a dangerous discussion to getting into, particularly in the UK context. It looks a bit uppity. We're kind of separating ourselves from the traditional. As I say, we don't even really operate the proper three branches of government as you do in the US. But I think the UK conception is very much in the third branch would be supporting the executive.
Thank you.
I'm happy to talk
Yeah.
a little bit about the sort of Fed as different from other agencies. I guess I'd point to two things that appear in the sort of American scholarship and have come up in the American litigation. So the first is this idea that monetary policy making is not executing the laws of the United States. That buying and selling treasuries is not a particularly executive function. And so some people say that that's like just different. The originalists in the American Academy say sort of build on that in a couple of different ways. They look at the first and second Bank of the United States, which were precursors of the Fed, but quite different. Lev Menand has observed that the Fed is a government agency with powers to supervise banks. The Bank of the United States was a private bank chartered by Congress with no ability to supervise other banks. But the first and second Bank of the United States did affect monetary policy because they could discount the notes of other banks. And by providing steep discounts to banks that didn't support their notes with hard money, the Bank of the United States controlled monetary policy and led to a stronger dollar, at least in theory, than would otherwise have existed without that. So there you have Congress created during the founding era these independent banks that did monetary policy and that were separated from the executive branch. Ergo, the Fed is different. Other scholars say there's just things that some agencies do, and the Fed is maybe among them when it comes to monetary policy, which isn't sort of executing the laws. An example of this might be information providing agencies like the Bureau of Labor Statistics or something like that. The people who collect and tell us how many people are employed, what they're employed doing, that kind of stuff. That is not execution of the laws, but rather some sort of data provision stuff. I'm not sure I agree with that theory, but that's a sort of more functional as opposed to a formal and originalist story about why the Federal Reserve is different. And then I guess a final thing that some scholars have mooted, and people worry about how far this would go, is that if the central bank's ability to affect monetary policy derives from the Constitution's grant to Congress of the power to sort of mint coins and coin money. That's out there in Article 1 of the Constitution. It's a power given to Congress and not the president. And so maybe you can make some argument that the Fed, when it comes to monetary policy, is sort of not an independent agency, but a sort of creature of Congress, and therefore deserves some insulation from presidential control because it's serving its congressional masters in coining money and in the amount of money that it coins. So not to go on too long, there's three different stories. There's the originalist story. There's the buying and selling treasuries doesn't look like executive story. And then there's this congressional control story about really the Fed is serving a congressional function and should be supervised by Congress rather than the president because it's coining money, essentially doing it's the delegate of Congress when it comes to Congress's power to coin money.
David, give us the skinny. Do you think that the court's going to choose one of those stories and which one? Or is it going to dodge the bullet? Or is it even possible to dodge that bullet?
I think it's going to go with this sort of originalist account. I think there's a couple of scholars who sort of did the work on this, conservative, credentialed scholars who said, look, the Fed's monetary policy, not its bank supervisory policy. The Fed has in the past taken the view that bank supervision and monetary policy should be combined in one central bank because that means that the Fed is close to the large banks who are sort of coining money. Most of the money created in America is created by these private banks. The Fed's taken the position that understanding how they're doing is important to setting monetary policy. And that, I think, there's no way back. I expect that the Fed's supervisory powers will be cleaved off, and that the vice chair for supervision will be removable at will, probably by the president, and that way the president will control bank supervision. But I think that, and the Supreme Court has indicated with some, pretty off-hand remarks that this originalist story is somewhat compelling to it, that the first and second bank of the United States are different and were separated from the executive branch and count as close enough to precursors to what the Fed does when it comes to setting monetary policy, that is going to be the legal basis for Fed independence. And it's a little weird. You can draw that distinction but you can draw lots of distinctions about what agencies are doing and how that's different from other things that other agencies do. But that, I think, is where the Supreme Court's indicated it might cite the independent power of the Federal Reserve. So I predict an originalist story that's kind of gonna be pretty limited, and people aren't exactly gonna understand what it means. But it will mean that she'll probably get to keep her job, and she'll probably get to keep her job because the first and second banks of the United States existed.
By happenstance. Michael Ioannidis, did you want to say something? I saw you were unmuted.
I mean, if you want the perspective of Europe on your question on where there's a difference between the central bank and agencies.
I would just be mindful of the time. We have about 2 minutes till we have to transition, and hopefully give a minute or to people to run to
Okay. I mean,
Okay.
I think I already gave an impression of what the answer would be. But an additional dimension to what I said, I think it also depends on the function that the central bank performs. I think we need to draw a distinction between monetary policy and banking supervision for central banks that do both. And it is true that a central bank that when and to the extent it does banking supervision comes closer to an agency than it is when it does monetary policy. And we also have this reflected in the protections of its independence in Europe. I mean, for us, the answer is clear. The central bank cannot be equated with an agency. It is provided for in the Constitution itself. It's, as Michael said, awarded special and different deference from the Court of Justice. So for us, and there is no delegation doctrine implied here for these reasons. But I think there is something to be said on the function as well. I mean, banking supervision is a bit different from monetary policy.
Okay, great. So I think just because we have another part to